Jefferson County Court, Law number 2 is in session. The court is in session with 2 dockets. First docket is the motion to revoke probation docket. First case is cause number M320880, case is styled the state of Texas versus Roberto Abraham Alfaro. Mr. Alfaro is appearing via Zoom. Mr. Alfaro, you can take your mic off of mute. How you doing, Alfaro?
Oh, pretty good, sir. Pretty good.
And Mr. Alfaro, you are represented in this case by your attorney, Attorney Efren Torres. Mr. Torres, how are you doing? He's also appearing.
Good morning, Your Honor. We're doing well. Thank you.
Okay. And the state is represented in this case by Attorney Erica Porter. Ms. Porter, how are you doing?
I'm doing great, Marlon.
Probation Office is represented in this case by Mr. Gary Gilliam. Mr. Gilliam, how are you doing?
Fine, thank you, sir.
Okay. And Ms. Gilliam or Ms. Porter, what is the state's recommendation in this case?
You're asking for my.
Yeah,
Okay, the state's recommendation is for revocation.
revocation. Okay. Now, Mr. Torres, the state is recommending revocation in this case. What is your position on that? What is your announcement?
Judge, we're in agreement with the revocation, Judge. We did provide the state some documentation that maybe they would consider, but we are in agreement with that, with the revocation, Judge.
Okay, so we need to reset this case on now, first of all, Mr. Torres, Ms. Porter is a new prosecutor. I think this is a second week here in court. You said you provided the state with some documentation. Do you know what attorney you gave that documentation to? What prosecutor?
Yes, Judge, that was T. Coleman, who I believe is no longer with your office. And I sent him a verification of incarceration from Bexar County, Your Honor.
Okay, so Ms. Porter is going to check with Mr. Coleman. We need to set this case and the date that we set this case for, both you and Mr. Alfaro need to be here in person.
Great, Judge. And just for my client's understanding, Judge, things that we've talked about, Judge, you do not hold these revocation hearings through Zoom, correct? Even though they may be agreed.
Right. No, well, no, because if there's a possibility of incarceration, there's no way we can get him to jail being on Zoom.
I understand, right? And that's what I try to make clear to him. I wanted to let him know, look, we have to go there to Jefferson at some point, right?
Right.
And get it done.
Right.
Okay. So then will I just be conferring with Ms. Porter from here on out?
Yes. Now, in reference to him appearing, normally when there's a contested hearing, the state has to agree to that. Yeah, let me see, there's a form there. It's on the, it should say article. Hold on a minute. Now, Mr. Torres, pursuant to Article 27.18, the state has to agree to the person not being here in person. Okay.
Okay.
So, so at this point, the court is going to set this case for a hearing. Well, set this case for disposition. Give us a reset date.
Your Honor.
This one? Yes.
With that date in mind, Judge, initially our hope was to be there today, Judge, but my client is having a little bit of vehicle issues. He hopes to obtain one by September. I'm not sure that's a little bit too far out or not, but that's just the reason why we were not able to go there today, since he has no mode of transportation to get to Jefferson, Judge. That's the issue. So I'm not sure if we can give him a little bit of leeway in order to just push it back instead of like a week or two or anything of that nature.
State, you have any objections to that?
No objections, just within a reasonable time frame. I would say no more than 45 days if he can get a vehicle. Otherwise, he can find a way down here.
Okay,
That's fine, Judge.
45 days, give us a 45-day reset. That'll be the first week of September, I think.
Question, sir.
Yes,
Sir, is this being set for a contested hearing?
he says that they're gonna dispose of the case on that day.
Well, he agreed to revocation.
But,
That's what he said.
but,
You can prepare it just in case.
I think we probably should.
Okay,
If he's saying he agrees
right,
and we don't, there's no term set yet.
right, right. Okay, yeah, you could just,
Set it for
be
contested.
prepared.
I mean,
Yeah, but I mean, if they can always dispose of it on that day.
Correct, Judge.
Right. Okay, this case is gonna be reset to September 13th of 2023. And Mr. Alfaro, your attorney will be sending notice of your reset date. Stay in contact with your attorney and your bondsman. Your bondsman will also get notice of the reset date. This will conclude your case. You're free to go. You have a blessed day. And Attorney Torres, your reset will be sent to you. You're free to go as well, and you have a blessed day.
Thank you, Judge. And that's going to be the 13th of September, correct?
Yes,
Okay. And then-
13. Yes,
And then I'll go ahead and reach out to Ms. Porter here shortly, Judge, after maybe docket. And go from there.
okay, that's fine. All right,
Thank you so much.
all right.
Appreciate it.
You welcome.
Thank you.
You need, pull your pants up, Mr. Lewis. Okay, this is cause number M332894, case of Style of State with Texas versus Edward Lator Lewis. Mr. Lewis, is that your full name? How are you doing, Mr. Lewis? That's good, Mr. Lewis. You're represented in your case by your attorney, Alan Parker. Attorney Parker, how are you doing?
Good, Judge, thank you.
Mr. Parker, what is your announcement in Mr. Lewis's case?
We're asking for one reset, Judge. I've got a tape, but I can't, it's not working. I need to
Okay.
go to the DA's office to get that done, and I need to talk to the DA's office about an offer, about resolution of it.
Okay, how much, give us a reset
Just a
date?
regular reset, I think that'll be sufficient.
Okay, September 20th is fine.
Fine.
Okay, this case will be reset to September 20th of 2023. Mr. Lewis, your attorney is gonna get your reset. Once you get your reset from your attorney, you'll be free to go, and you have a blessed day. And Mr. Allen, once you get your reset, you'll be free to go as well. And you
I've
have,
got two other.
you have another? Okay.
Well, yeah, you can go and just call me later. I have a Theodore Thornton.
Oh, okay. Okay,
He's right up.
Theodore Thornton.
You don't have it?
He's the last one on my docket.
I've had lots.
It's
of
on the
discussion with
announcement.
Toby, but it's a mess.
Theodore Thornton is a harassment case.
Mhm.
Do we have bond conditions in this case?
There's, well,
There's
there's a lot there.
Okay.
Well,
Let me do this here. This is called, let me do somebody's on. This is cause number M333574. The case is styled as State of Texas versus Theodore Thornton. Mr. Thornton, is that your full name?
Yes, sir.
How are you doing, Mr. Thornton?
Truly blessed, and you?
I'm blessed as well. Thanks for asking. Mr. Thornton, your attorney is Attorney Carl Parker. Attorney Parker, what is your announcement in Mr. Thornton's case?
Judge, just let the court know, there's, in relation to this involves, there's a family case involved. So there's all kind of orders in place about, he has kids of his own, and his wife has kids with another man who's the alleged victim in this case.
Yes, sir.
And so there's a lot of stuff going on in family court. The last time I talked to Mr. Hoffpower, we were trying to get some resolution to that. And we've been in constant contact about this case, and we're wanting some time to see what's going to play out with that. And I think this is going to kind of edge on partially on how we resolve. I'm not representing in the family case, but
Okay.
it's going to resolve on that. And there's some discovery that I don't have.
Okay.
There's a tape, which I don't have a copy of, and I'll submit another request, but I don't
Okay,
know if it just got,
so your discovery is not completed.
no, sir.
Okay, State, do you have any objections to the reset? We're gonna reset. He still needs time to get his discovery.
No.
Give us a reset date.
Yes, I do know. Okay.
What date is that?
Have you talked to Kobe about that? I'll fill you in.
Okay, the case is reset to September 25th of 2023. Mr. Thornton, make sure that you continue to stay in compliance with your bond conditions, and your attorney is going to get your reset. Once you get your reset from your attorney, you'll be free to go, and you have a blessed day. And is this your last case?
Judge,
Because I don't see your name on it.
well, it shouldn't be on there. I got hired yesterday evening by a Marquise O'Neill. He's outside. But
Yeah, just go have a
so
seat.
by the time we got hired, we sent in a letter of rep, but I think they called the court and they said
It hadn't.
they hadn't processed yet, so he needed to be here. So I'm just letting.
O'Neill?
I'm representing him, and I've sent a letter of rep in, and he is here.
Why don't you get Mr. O'Neill?
I guess he's on the, I don't know, you call it the initial doc. I'm not
Oh,
sure.
he's on the announcement docket.
Okay.
Yeah, well, is Todd LeBlanc represent? I had Todd LeBlanc down here. You might have to do you might have to do the motion to sub. If I see a turn, look at that file and make sure, was it rescinded? Oh, he was appointed. Okay. So Mr. O'Neill, would you please come forward? This is cause number M323788. The case is styled the State of Texas versus Marquise T. O'Neill. Now, Mr. O'Neill, the docket shows that your attorney record is Attorney Todd LeBlanc. However, Mr. Parker has just informed the court that you hired him to represent you, right?
Yes, sir.
Now, Mr. LeBlanc was appointed. And so so Mr. Parker, get that motion to sub in.
I need a motion to sub, just give him notice that I've been hired.
It's a motion to sub. Yeah,
Okay, well,
yeah, you could, we're gonna reset the case to give you time to get the motion to sub in. Okay. And that'll give, once you get that motion to sub, that'll give notice to Mr.
Mr. LeBlanc gonna be here today?
He's supposed to be here today for Mr. Marquise. Had you, somebody's coming in the door. Mr. Dahl, you need to get your coat. You need a coat?
Yeah.
Don't come, just hold on a minute. Yeah. Okay.
I'll file a motion to substitute, Judge.
Okay. Okay. What we'll do is, we can just reset and let, with Mr. LeBlanc, we'll let him know that, he's hired Mr. Parker, and Mr. Parker be following motion sub. Okay, so let's, we're gonna give you a reset to give your attorney the opportunity to do that. We just keep it on announcement docket.
Yes, sir.
So your attorney has to get the discovery and all of that information,
Yes, sir.
get access to that information. Okay. Okay.
Excuse, Judge.
Yes, you may be excused. Okay, we're gonna get a motion sub to him, to stand, I mean, that's a motion, the reset.
Oh, yeah, not to see.
Jefferson County Court at Law number 2 is in session. Make sure we have bond conditions in this case. Copy reset. Give them. The cause number is M333202, case of style of state of Texas versus Reginald King. Mr. King, is that your full name?
Yes.
How you doing, Mr. King?
All right.
I'm doing fine. Thanks for asking. Mr. King, you're represented in your case by your attorney, Attorney James Paget. Attorney Paget, how are you doing?
I'm doing well. Good morning, Your Honor.
Good morning. Mr. Paget, what is your announcement in Mr. King's case?
Your Honor, we've received all discovery except for the videotape. I put in this request originally on the 12th, and then when they changed the procedures, I put it in again the second way, and I still haven't received it. So I don't expect it to take too much longer. I've received all the other discovery, and I just need to review the videotape with my client, and we're prepared to move forward.
Okay.
He's been very responsible with me. We communicate on a regular basis.
Oh, that's good. Yeah. I got okay, this case will be reset
So
to September 20th of 2023. Is that good with your schedule?
that's fine. Your Honor.
Okay. And
We'll be around.
Mr. King, your case is being reset to September 20th of 2023. Your attorney is going to get your reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day.
All right, thank you. The next one is McGowan. Is this your case or Kobe's?
Let me see.
I spoke to Kobe about it last time in Western.
It's my case.
I tell you what, we're just gonna release it if you can just make, and I'll email you just.
Check to see if we got bond conditions in this one too.
Because, that's the only thing.
This is cause number M333468, case of style of state of Texas versus Trayvon M. McGowan.
Yes, sir.
Is that correct?
Yes, sir.
How you doing, Mr. McGowan?
No, good, sir. Thank you, sir.
That's good. Mr. McGowan, you're represented by your attorney, Attorney James Paget, Attorney Paget. What is your announcement in Mr. McGowan's case?
Your Honor, we've received all discovery on the case and we're ready to move forward. The issue is I spoke to Mr. Hoffpower about it last time about getting an offer and I still don't have one. Evidently, Ms. Porter's now been assigned the case, and we have a good report. I'll email her and just a reminder, I know she's made a note to make me an offer. That's the only thing holding us up. We're ready to move forward in the case.
Okay. Yeah,
And then we'll set up.
Did I have that?
that?
I gotta give them some bond conditions.
Do it around.
Yeah, I need to give them some bond.
So what the judge is gonna do right now, on every bond, there are certain conditions. So he's gonna place some conditions on the bond right now. There's nothing unusual here. You haven't done anything wrong. The court's policy in every bond, there will be certain conditions, depending on the type of case. But if you'll just listen to him, he's gonna read it to you. Some of these conditions don't apply to you, and he'll let you know which ones do and don't.
It's, my God.
You know, right over it. I'm gonna get back to my office, Ms. Porter, I'll just shoot you an email. You might have a few things on my one case, maybe. Yeah, I've been there, done that, understand. Do understand. I mean, I have not even a third of what you do. A little bit easier to remember.
Take a copy of this. Come here.
We're gonna make copies of it all.
Yeah, you'll get a copy of the bond conditions for your record.
Not- Paperwork, 17 today and so. Thank goodness. For his sake, anyway.
I'll send you.
One person's doing it.
Yeah, that's just for your client.
So I'm gonna put this in front of you. And again, you don't need to resolve. Let you know the points. Maybe the books.
Mr. McGowan, your attorney just gave you a document that is titled Standard Bond Conditions in County Code at Law Number 2. Do you see that title?
Yes, sir.
I will go over these conditions, which it says following the return of a criminal information in County Code at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. And Mr. McGowan, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest and you'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, now, your case has been reset till September 2023. Your attorney will give you a copy of the reset. Once you get a copy of the reset, you'll be free to go and you have a blessed day. That's September 20th, right?
Today, you take that with you, it's yours.
Oh, okay.
And, my man. It's always good seeing you, but we'll stop this.
Okay, now. You have any other cases? This is the last case? Okay, Mr. Padgett,
Yes, sir.
you're free to go and you have a blessed day.
Thank you. You have a blessed day as well.
Okay.
Thank you, Mr. Flores.
He doesn't represent it yet.
Well, that's okay. Would you, do you?
Jefferson County Court, law number 2 is back in session. Next case is cause number M3263446. The case is styled the state of Texas versus Philip Randall Holmes. Mr. Holmes, is that your full name?
Yes.
Mr. Holmes, how are you doing?
Okay.
That's good. Mr. Holmes, you are represented in your case by your attorney Scott Rennick, who is appearing via Zoom. Attorney Rennick, how are you doing?
I'm good, Judge. How are you, sir?
I'm doing fine. Thanks for asking. Mr. Rennick, what is your announcement in Mr. Holmes' case?
Your Honor, from what I understand, Mr. Holmes is still participating in Veterans Court, and this was just a check-in. I haven't received anything from the state stating otherwise.
Okay. Now, Mr. Rennick, I need to ask Mr. Holmes some questions about Veterans Court. Do I have your permission to ask you some questions?
Yes, Your Honor.
Now, Mr. Holmes, just raise your hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand down. Now, you are still participating in the Veterans Court program?
Yes, sir.
When is the next date that you're required to go to Veterans Court?
Sure. Usually they let us know beforehand.
So they contact you like a couple of weeks before the report date?
Pretty soon.
Okay, now when was the last time you went to Veterans Court? About a month and a half ago? How long have you been in the program?
Program. 14 months. Sure.
It has been a while, Judge. It has been.
Is there have they informed you as to when it's supposed to end?
On the next Veterans Court, should be the last time to go.
Oh, okay. Okay, so you,
I've met all the requirements of conflict treatment, so good to go, passed everything you should pass and, maybe benchmark social everything. So just wait for the next Veterans Court and you say that, hey, it's good to go, release me.
okay. Now, I was wondering, how often did you have to go to Veterans Court?
Veterans Court is like once every 3 months or something. like
Every
that.
3 months, and the last time you went was when?
A few months back.
2 months back, so it's probably coming up pretty soon. What we'll probably do is maybe give him a standard reset, hoping that he would have already been to Veterans Court when he comes back to court here. Okay, give us a reset date.
And Judge, if I receive anything showing that he's completed it, I'll immediately file it with the court at that point.
Okay.
I just don't, I've contacted them. I haven't received the information saying he's completed, but it's got to be coming up soon because he's been on this for a while.
Okay. Okay, give us a reset date.
September 25th.
Okay, this case is gonna be reset to September 25th. So that's about 2 months. So hopefully you would have completed the program by that time. Okay, now, Mr. Holmes, first of all, the court would like to commend you for your participation in that program and just continue to comply with the requirements of that program. Your case is going to be reset to September 25th, 2023. You will get your reset here in court from our court administrator. Once you get your reset, you'll be free to go and you have a blessed day. Would you please stand over in front of our court administrator? And Mr. Rennick, this is your only case.
Yes, Judge.
You're free to go as well, and you have a blessed day.
You too, Judge. Thank you.
Okay, and your reset will be sent to you.
Okay, thank you, Judge.
Okay, you're welcome. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M322724. Cases style of State of Texas versus Timothy Ray Hall. Mr. Hall, would you please come forward? Mr. Hall, your full name is Timothy Ray Hall? Okay, Mr. Hall, would you please raise your right hand? Mr. Hall, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? So help you God? You can put your hand down, Mr. Hall. How are you doing, Mr. Hall? You're doing not too good? You have any physical ailments, any illnesses?
I've just been going through a lot. I see my cousin passed. It's been a toll on me and my family and stuff.
Okay.
So really, I've just been a fighting person and everything.
Okay, now, Mr. Hall, let me do this here. The court has scheduled this case for what is called a judicial review. You're currently on probation. You've been on probation since March 1st of 2021. And you had a 1-year probation, and through that period of time, you've been given some extensions. Now, the court is going to have this proceeding, and in this proceeding, there probably will be some disclosure of non-public information. What that means is going to be some information that the public shouldn't have access to as private information. And because of that, the court is mindful that Article 1.24 of the Texas Code of Criminal Procedure states that all proceedings and trials shall be public. However, pursuant to a case that is titled Lilly versus State, the site is 365 Southwest 3rd of 321. The right to a public trial is not absolute and may be outweighed by other competing interests. What that basically means is that there's an exception to the rule. Okay. And one of the exceptions is you have a right to have this hearing closed to the public to prevent the disclosure of non-public information. So to prevent the non-public information from being disclosed to the public, obviously, we're on YouTube, we have peak personnel in the courtroom. We can close that hearing. There's this portion of the hearing to the public. So your non-private information would not be heard by the public. Do you understand that? And so do you want to do that? You do? Okay. So the court finds that the parties seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced to the defendant, and the closure is no broader than necessary to protect the defendant's interests. The trial court has considered other reasonable alternatives to closing the hearing, and the findings that this court is making are adequate to support the closure. So at this time, this hearing will be closed to the public. We're going to